This hearing starts off sounding calm, procedural, almost routine. But do not let that fool you, because what is actually happening here is serious. We are looking at a child support enforcement case where the numbers are already massive before anyone even begins arguing contempt. The court is dealing with tens of thousands in unpaid child support, more than 24,000 in medical arrears, ongoing monthly obligations, and now the possibility of contempt on top of all of it. That is where this turns from a money problem into a legal danger zone. And here is what makes this case especially tense. A lot of the financial issues appear to be agreed, but the contempt portion is still hanging in the air like a storm cloud. That means the courtroom is no longer just talking about what is owed. It is talking about what happens when court orders are not followed. And once contempt enters the conversation, the stakes jump immediately. We are now in the territory of probation, supervision, possible revocation, and yes, even jail time if things go wrong later. Watch closely because this judge is doing something very important here. She is not just processing paperwork. She is making sure the person on the other side truly understands what contempt can mean, what community supervision requires, and what kind of consequences can be triggered if payments stop again. That matters a lot. Because in family court, misunderstanding the order can become the next violation. So as this unfolds, pay attention to three things: the huge arrearage numbers, the shift from pure debt into contempt enforcement, and the judge's effort to lock down a clear agreement that cannot be misunderstood later. The big question is this: is this a fair second chance with structure, or is this just the court's final warning before much harsher consequences kick in?
We're here on a motion for enforcement that was previously filed on May 14th of 2025 by the Miss Armus. And it's come to the court's attention that there are some agreements, and the only issue that the court needs to take up is the contempt portion. Is that correct, counsels?
Yes, ma'am.
Yes.
All right. Okay, if you want to proceed, Attorney Adamson, and read the agreements into the record.
Judge, the agreement is that a judgment will be found for child support arrearage in the amount of $69,612.82. A judgment would be entered for medical arrears in the amount of $24,140.96. The ongoing child support in the amount of $1,237 would continue. The ongoing medical support of $250 would continue. That in addition to those two payments, a payment towards the arrearage on child support in the amount of $250 a month would be added, and in the amount of $150 a month for medical support would be added, making a total of just under $2,000 per month.
Okay. Does that conclude the agreement, counsel?
Yes, Judge. The judgment as of dates is November 30th, 2025 for both amounts.
Let's pause right there, because these numbers deserve a spotlight. The court is not talking about a small missed payment or a minor dispute. We are talking about $69,612 in 20 cells and 624 arrears, and 24 cells and $140 and 26 times S and medical arrears. That is already over $93,000 owed, and that is before you even add the ongoing monthly support obligations. Then the agreement stacks on extra monthly payments toward the back debt, bringing the total monthly burden to just under $2,000. In plain terms, this is the court building a payment structure that tries to keep current support going while also attacking the old debt. And this is where viewers need to understand the legal pressure point. Once arrears get this large, enforcement becomes much more than an accounting exercise. The court needs a workable compliance plan. That is why the agreement matters, but it is also why contempt still matters. Because the judgment tells everyone what is owed, while contempt addresses the failure to obey prior court orders. One is about the money on paper. The other is about the court's authority. So here is the real tension. Is this payment plan genuinely realistic, or is it setting up another future crash if the defendant cannot keep pace? That is the kind of question family court judges are quietly weighing even when the hearing sounds polite and procedural.
All right. And regarding the contempt, the court will take up testimony on that. Well, before we do that, what is the issue with contempt specifically?
I think the issue is simply no one wants to be held in contempt, Judge. I don't know that there is a defense to it. I'll let Mr. Castillo address that. We have agreed to forego any jail time for now, pending future obedience to the court orders.
Okay. All right. So, well, Mr. Castillo, jail time is not, let me make sure this is, okay, Mr. Castillo, jail time is not the only option for contempt. You understand that, right?
Yes, I think I do, yes.
Okay, so you know, if you're held in contempt, you could also be placed on community supervision, probation.
I did not know that, but now I do, yes.
Yes. So even if I were to find you in contempt, that doesn't necessarily mean that I have to place you in jail.
Okay.
Okay. And I'm not trying to change your mind. I just want to make sure you understand that. And so I'm going to ask, does that change your mind about wanting to proceed with having a hearing on contempt, if that's an option for you?
That's an option. I would not like to continue.
Okay. So what I can do is Attorney Adamson, if you would have a conversation with Mr. Castillo, I can that'll give me an opportunity to bring the community supervision community supervision officer into the courtroom, and that way he can get their contact information.
Happy to do that, Judge.
Okay, so let me place you all back in a waiting room. Excuse me, waiting room, breakout room.
This is one of the most important moments in the whole hearing, and the judge handles it very carefully. Notice what she is doing. She is slowing everything down to make sure Mr. Brain, Castillo, understands that contempt does not automatically equal immediate jail. That is a huge clarification. A lot of people hear the word contempt and mentally jump straight to handcuffs, but the court is explaining that there are intermediate consequences, including community supervision or probation-like conditions. That changes the entire strategic picture. And then comes the subtle but powerful turn. Once he realizes jail is not the only outcome, he no longer wants to continue pushing for a contempt hearing in the same way. That tells you something. Whether it is fear, uncertainty, or simply reassessing risk, the legal landscape suddenly became very real. This is exactly why judges make these records so carefully. They do not want someone coming back later saying, "I did not understand what I agreed to." Also, let's be honest. That line about no one wants to be held in contempt is probably the understatement of the day. Of course no one does. But family court is full of cases where people ignore orders until the consequences become concrete. The question for viewers is, does this sound like someone finally taking the situation seriously, or someone reacting only because the possibility of supervision and future jail has now been spelled out in plain English?
Okay, so in regards to contempt, is the agreement to find that Mr. Castillo is in contempt of court?
Yes, ma'am.
Okay, and what is the remaining agreement?
That there'd be 12 months of the community supervision in lieu, and the sentence would be stayed pending continued payments being made.
All right. Did you all have an opportunity to discuss, in the event that payments aren't made and there is a motion to revoke file, what that sentence would look like?
No, ma'am. I assumed it'd be the normal 180, but we did not go into specifics with Ms. Castillo.
Okay, so Mr. Castillo, typically it is 180 days per violation, okay? But Mr. Adamson, if that were to happen, Mr. Castillo, that's not to say that it will happen, okay? As long as you stay on top of doing what you're supposed to do on community supervision, you don't ever have to worry about triggering that portion. But Attorney Adamson, are you asking that the for the violation that it's 180 days to run concurrent?
We would have it run concurrently, yes, Judge.
Okay, so Mr. Castillo, that means that instead of the 180 days per violation, it'll be 180 days in total if your community supervision were to be revoked. Do you understand that?
What does it mean by 180?
180 days. So you'll be placed on community supervision. I'll be with you all in just a minute, okay? You'll be placed on community supervision for the 12-month period. So in that 12-month period, you just have to make your payments on time for child support as well as your medical support. If for any reason you fail to abide by the court order, like your court order to do so, Ms. Armus could file a motion to revoke your community supervision for that 12 months. And then you could potentially be placed in jail at that time, but the jail sentence will not exceed 180 days.
Okay.
Does that make sense?
Now the court has moved from theory to mechanics, and this is where things get serious in a very practical way. Mr. Castillo is being found in contempt, but the sentence is effectively being stayed so long as he complies during a 12-month period of community supervision. That is the courtroom version of saying you are being given a structured chance to prove you will follow the order from here forward. But if you fail, the consequences are already being built into the record. The judge is also doing something smart by forcing clarity on the jail exposure. At first, there is uncertainty about what the sentence would look like if supervision is revoked. Then they settle the point that the time would run concurrently, meaning 180 days total, not 180 days stacked over multiple violations. That is a big distinction. In legal terms, that could mean the difference between a severe warning and a catastrophic outcome. And look at Mr. Castillo's response when he asks, "What does it mean by 188?" That moment matters. It shows why judges cannot assume everyone understands courtroom shorthand. Viewers, this is exactly why precise explanations matter in family court. A confusing order can turn into a future disaster. So what do you think? Is the court being lenient here by capping the risk at 180 days total? Or is this already a very strong sanction considering the size of the arrears?
Yes, it does. Thank you.
Okay. All right. So the community supervision officer, he might be busy. He's not available right now, but Attorney Adamson, when you prepare the order, could you just make sure that you put that statutory language in there for the probation department? What the sentence will be, that the 180 days will run concurrent, and that Mr. Castillo is to report as ordered by the community supervision department.
Yes, ma'am.
Okay. All right. Is there anything else for the or did you all discuss attorney's fees at all?
No, ma'am, we didn't, and I should have.
Okay. Yes, you all should discuss attorney's fees. Because Mr. Castillo, as a part of contempt. Now, granted, you all can discuss it and decide not to do it right now, Attorney Adamson. And you can waive that right now. Well, not waive it, excuse me. You can reserve it to bring up potentially at a motion to revoke if you choose to do that.
I would need to talk to my client instead of doing that, Judge. Can we jump into the breakout room one more time? I apologize.
No problem. Just you and your client?
Yes, ma'am.
Okay. So what did you all come to?
We decided, Judge, that we would do the contempt with a 1-year supervision. And like everything we said earlier, that's the only addition we have. Okay. Oh, sorry. We were on attorney's fees. I'm sorry. It's been so long, I forgot. No, the attorney's fees we're going to reserve if there's a violation.
Okay. So we're back on the record. So we took a break for you all to discuss the attorney's fees as it relates to the contempt. And counsel, you can go ahead and state what you all's agreement was.
So the agreement is that we're going to reserve attorney's fees, any judgment on that pending any violation in the future.
Perfect. Thank you all. And thank you all for your patience, and thank you all for working this out too, okay?
Here is a detail that casual viewers often miss, but it matters a lot: attorney's fees. The judge catches it, brings it up, and suddenly you realize this case still had another financial layer waiting in the shadows. In contempt matters, attorney's fees can become part of the pressure, because the party who had to come to court to enforce the order may seek reimbursement for the legal cost of doing that. In other words, non-compliance can get more expensive than the original missed obligation. What happens here is strategically interesting. Instead of fighting over fees right now, they decide to reserve them for the future if there is another violation. That means the issue is not gone, it is part, and that creates another incentive for compliance. If Mr. Castillo makes the payments and follows the terms, that reserved issue may never explode. But if he slips, those fees can come back into play along with a motion to revoke supervision. So this is not just a cleanup detail. It is another warning built into the agreement. The court is basically saying, we are not adding this burden today, but do not mistake that for immunity tomorrow. That is a clever pressure valve. It keeps the case moving while preserving consequences. Would you see that as fair restraint by the court, or as one more layer of leverage to keep future payments on track?
Attorney Adamson, how long do you need to prepare the order?
7 days is fine, Judge.
All right, so let me put you all on a, I'm going to put you all on a dismissal docket for the order entry. And then I'm also going to do a report back because Mr. Castillo, I want to check in and see how everything is going, okay?
Okay.
All right, so I'll do 6 months. So pull out you all's calendar. So that'll put us around what, August?
Yes, ma'am.
Okay, so right now, the dismissal docket, the earliest I have is February 13th, that's next Friday. And Mr. Castillo, the way that works, Mr. Attorney Adamson is going to prepare an order and you'll have an opportunity to review the order after he sends it to you. You can agree, if everything looks good, you can agree to it, or you don't have to agree, right? And if you choose not to agree, you all will show up on that day and you'll state whatever your disagreement is, and the judge will more than likely sign the order. If you do agree, you can sign the order, or you don't have to sign it, because the only signature on it that matters is mine. And if that were to happen, you don't have to worry about appearing on that day, okay?
Okay.
All right, so let me go ahead and add this to the docket. Give me a minute. All right, so I have added you all to the entry/dismissal docket for February 13, 2026 at 9:30 a.m. That'll be before Judge Lee. Let me give you this Zoom code. Let me know when you all are ready.
Ready.
It's 961-1106-4392.
Got it.
All right. Any questions before we are done?
Did you want to set the 6-month review date as well, Judge?
Thank you. Thank you. I forgot that fast. So August, are there any dates that you all are not available in August?
No, ma'am.
No.
All right. So first available I have is the week. Do you know when advance? Do you know if the advance is going to be the 3rd or the 10th?
Oh, I don't know. I haven't been advanced in a while.
Let's do the 3rd. If you all are available, it'll be via Zoom.
I could do that.
All right.
I can as well.
Yeah.
Yeah, August 10th to the 13th, by the way, Judge.
Thank you. Mr. Castillo, can you do August 3rd?
Yes, I can.
And that'll be in front of me via Zoom. So let me go ahead and swear you in. Raise your right hand. Well, state your name.
Clayton Castillo.
All right. I am swearing you in to reappear on Monday, August 3rd, 2026 at 9 a.m. via Zoom, the same Zoom code you used today, 688-044-0164. Your failure to appear at their report back date could result in a KPs being issued for your arrest. Do you understand those instructions?
I understand.
Do you have any questions about those instructions?
No.
Okay, you may lower your hand. Is there anything else for the record?
No, ma'am.
Okay, Joey, do you have Shelton's email address? I can at least give it to Mr. Castillo right now. Mr. Castillo, let me go ahead and give you, and Miss Attorney Adamson, you can have it too, since we're on here. Is it the same Shelton.Brown? I believe it's Shelton, S-H-E-L-T as in Tom, O-N as in Nancy, .Brown, B-R-O-W-N at dallascounty.org.
Got it.
All right. All right. Thank you all again, and we'll see you back in August.
Thank you.
Judge.
You're welcome. Have a good day.
Usual.
Thank you.
So here is the professional bottom line on this case. The parties reached an agreement establishing major judgments for unpaid child support and medical arrears, while ongoing monthly support remains in place and additional payments were added toward the past due balances. On the contempt issue, Mr. Castillo was found in contempt, but instead of immediate jail, the court approved a structure built around 12 months of community supervision, with the sentence stayed so long as he complies. If he fails to follow the order during that period, the court made clear that the supervision could be revoked and a jail sentence of up to 180 days total could be triggered under the agreement as discussed. The judge also ensured that attorneys' fees were addressed, with that issue reserved for the future if there is another violation, and she set follow-up dates to monitor compliance. That is the broader implication here. This was not just a hearing about old debt. It was the court drawing a very clear line between past non-compliance and future accountability. Now, I want to hear from you. Do you think this outcome was fair, too lenient, or exactly the right balance between enforcement and giving someone one final chance to comply? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.